So, very good morning, friends.
Yeah.
On Sunday morning, we have assembled here to discuss SEBI regulations, and this is the coverage as per syllabus. So, SCRA Act is there, Securities Contracts Regulation Act. Then SATC, LODR, ICDR, and delisting. So, these are the topics which are covered in SEBI regulations. So, let us have a look at some of the provisions regarding Securities Contracts Regulation Act 1956. This is a preliminary sort of PPT. So we will be discussing it, and you can also share your feedback so that we can also improve upon it. So what is the objective? Primary objective of this, because it says Securities Contracts Regulation Act. So that means it is trying to regulate the contracts which are entered into by various parties. So the primary objective is to prevent undesirable transactions, because these securities transactions are subject to manipulation. We have seen in press reports also many a time concept of the dabba trading and all those things, trading beyond the stock exchange. So main objective of this act is to prevent undesirable transactions in securities by regulating the business of dealing therein, by providing for certain other matters connected therewith. So basically it tries to regulate the business of dealing in securities. And what are the other objectives? The other objectives are to promote a healthy stock market, to provide for the regulation of the stock exchanges, to provide for the regulation of transactions in securities, to prevent undesirable speculation or transactions in securities, to regulate the buying and selling of securities outside the limits of stock exchanges, and to provide for ancillary matters. And regarding the coverage, the act is applicable. पाटिल जी म्यूट कर दीजिए, जो या कोर्स जो भी है जहां से भी डिस्टर्बेंस आ रही है उन सबको म्यूट कर दीजिए. Coverage is the act is applicable to whole of India and it came into force with effect from 20th of February 1957. ठीक है, 21st February को मेरा बर्थडे होता है, एक दिन पहले ये एक्ट आया था. ठीक है, ये तो ज्यादा फर्क नहीं है. एग्जेम्पशन क्या है? एग्जेम्पशन फ्रॉम SCRA. The provision of SCRA, it will not apply to the following. Government पर apply नहीं होगा, RBI पर apply नहीं होगा, any local authority, any corporation set up by special law, any person who has effected any transaction with or through the agency of any authority referred from 1 to 4 above. So basically because these are more or less arms of the government or are being regulated by the government. So these are not covered under this SCRA. Any convertible bond or warrant or any option or right in relation thereto, insofar as it entitles the person in whose favor any of the foregoing has been issued to obtain at his option from the company or other body corporate issuing the same, or from any of its shareholders or duly appointed agents shares of the company or other body corporate, whether by conversion of the bond or warrant or otherwise, on the basis of the price agreed upon when the same was issued. So if besides these arms of the government, which include the government, RBI, local authority, or any corporation set up by any special law, or any person who has effected any transaction with or through the agency. Suppose you buy some securities from RBI, because RBI is also selling securities. Government is also issuing bonds at times. So if you are dealing with securities with any of these four, then you are exempted from the provisions of SCRA, which basically aims to regulate the transactions in securities market. Besides this, if you have been issued any convertible bond or share warrants or options, which are convertible into equity shares, so then also, but the price was already agreed to when the same was issued. Suppose you were issued a bond or you were issued a warrant and the time was already agreed to when the same was issued, then also you are exempted from the provisions of SCRA. Besides this, any class of contracts in respect of which an exemption notification, so government may also issue a notification that, okay, this particular class of contracts will also be exempted from the applicability of SCRA. Central government can issue notification if it is satisfied that it is necessary in the interest of trade and commerce or the economic development of the country. Such exemption may relate to the entire act or only to certain provisions thereof. So they may exempt any class of contracts from the entire act or from certain provisions of the act, and may also specify the conditions, limitations, or restrictions subject to which the act shall not so apply. So, by way of notification also, they may exempt. So, these are the exemption provisions. Now, definition of terms. Contract, because it is seeking to regulate the contracts. So, what is meant by contract? So, contract is a contract for or relating to the purchase or sale. So, purchase or sale, both are covered. Corporatization, so we'll refer it later. Demutualization, derivatives. What is derivative? Derivative, it includes security derived from a debt instrument. Behind the derivative, there is an underlying security. So it includes security derived from a debt instrument, share, loan, whether secured or unsecured, risk instrument or contract for difference or any other form of security. Then contract which derives its value from the prices or index of prices of underlying securities, commodity derivatives, and other instruments as declared by central government to be derivatives. So this is the definition of it is an inclusive definition, and it includes certain underlying securities or securities derived from certain instruments. Then government security, it means a security created and issued whether before or after commencement of this act by the central government for the purpose of raising a public loan or having one of the forms specified under section 2 subsection 2 of the Public Debt Act. Goods, so every kind of movable property other than actionable claims, money and securities is goods. So goods are also defined in SCRA. Commodity derivative, so commodity derivatives basically it means a contract for the delivery of such goods as notified by central government and which is not a ready delivery contract, or for differences which derives its value from prices or indices of prices of such underlying goods or activities, services, rights, interest and events as notified by the central government in consultation with SEBI, but does not include securities as referred to in points 1 and 2 above. We are being referred to as derivatives. Member means a member of the recognized stock exchange. NTSDC, non-transferable specific delivery contract. Then option in securities, RTP. So it means a contract for the purchase or sale of a right to buy or sell, or a right to buy and sell securities in future, and includes a teji mandi, a gully, put and call. Most of you who are dealing in stock market must have already heard these terms. Prescribed, naturally prescribed by rules. Ready delivery contracts. Ready delivery contract is a contract which provides for the delivery of goods and the payment of a price thereof, either immediately or within a certain time period after the date of contract and subject to conditions notified by the central government in respect of any goods, the period under such contract not being capable of extension by the mutual consent of the parties thereto or otherwise. So, ready delivery contract, that means you have to complete the transaction within a specified time period and it is not extendable even by mutual consent. Such contract shall not be deemed to be a ready delivery contract, whereas any such contract is performed either wholly or in part by realization of any sum of money being the difference between the contract rate and the settlement rate, or clearing rate, or the rate of any offsetting contract, or by any other means whatsoever, and as a result of which the actual tendering of the goods covered by the contract or payment of the full price therefore is dispensed with. So if you are netting off the transaction, you are either realizing the difference or you are paying the difference, then it is not a ready delivery contract. Recognized stock exchange is a stock exchange which is for the time being recognized by the central government. Rules. Rules, as we have already seen, prescribed. With reference to the rules relating in general to the constitution and management of a stock exchange, the term rules includes, in the case of a stock exchange, which is an incorporated association, its memorandum and articles of association. So prescribed means prescribed by rules, and rules are with reference to the rules relating in general to the constitution and management of a stock exchange. The term rules includes In the case of a stock exchange, which is an incorporated association, its memorandum and articles of association. Scheme is also referred later on. Then Securities Appellate Tribunal, SAT. So it means the Securities Appellate Tribunal established under this section. Then securities. Securities includes shares, scrips, stocks, bonds, debentures, debenture stock, or other marketable securities of a like nature in or any incorporated company or other body corporate. Derivatives are also included in securities. Then units or any other instruments issued by any collective investment scheme to the investors in such schemes. Security receipts as defined in SurFaCI Act. We have seen in SurFaCI Act that security receipts are issued by the ARCs to qualified institutional buyers, and units or any other such investment issued to investors under any mutual fund scheme. So all these are included in the term securities. Any certificate or instrument, by whatever name called, issued to an investor by an issuer being a special purpose distinct entity which possesses any debt or receivables, including mortgage debt assigned to such entity, and acknowledge beneficial interest of such investor in such debt or receivable. Government securities are also included. Then instruments notified by central government to be securities, and rights or interests in securities. So this is the definition of securities as per SCRA. SDC, specific delivery contract. Then spot delivery contract. So in spot delivery contract is a contract which provides for actual delivery of securities and the payment of a price, therefore, either on the same day as the date of the contract or on the next day. The actual period taken for the dispatch of the securities or the remittance of money, therefore, through post will be excluded from the computation of the above period if the parties to the contract do not reside in the same town or locality, because it is an old act. So it is taking into account the time period which is taken. Then transfer of securities by the depository from the account of the beneficial owner to the account of another beneficial owner when such securities are dealt with by a depository. Stock exchange. It means any body of individuals, whether incorporated or not, constituted before corporatization and demutualization. A body corporate incorporated under the Companies Act, whether under a scheme of corporatization or demutualization, we will understand these concepts. And for the purpose of assisting, regulating, or controlling the business of buying, selling, or dealing in securities. So this is the definition of stock exchange. Then TSDC, transferable specific delivery contracts. So these are some of the terms which are used in SCRA. And now how a stock exchange is recognized. Stock exchange recognition of stock exchange. This is given in section 3 and 4. The power to recognize a stock exchange vests with the central government. However, it has delegated these powers to SEBI. As RBI is the regulator for banks, similarly, SEBI is the regulator for stock exchanges. So the recognition to stock exchanges is awarded by SEBI. Application for recognition. So any stock exchange which is desirous of being recognized should make an application to SEBI under section 3. Form of application, it has to be in form A with fees of 500, and the application shall be accompanied by 4 copies of articles, bylaws, and rules and regulations. You can check for the latest fees because this is as per the Parent Act, but from time to time they keep on changing the fees. Then contents of articles, bylaws, rules, and regulations. The articles, bylaws, rules, and regulations, they must contain specific details on the following points. So as you must have read the regulations regarding IPA, insolvency professional agencies, similar are the rules here. So it says that the articles, bylaws, rules, and regulations, they must contain specific details on governing body. Who will be the governing body of this stock exchange, its constitution, powers of management, and manner in which its business is to be transacted. Then powers and duties of the office bearers of the stock exchange. How admission will be done to the stock exchange of various classes of members, what will be the qualifications for membership, and in what manner members can be excluded, suspended, expelled, or readmitted therefrom or thereinto. Besides this, the bylaws, they will provide for the procedure for registration of partnerships as members of the stock exchange in cases where the rules provide for such membership, and the nomination and appointment of authorized representatives and clerks. So generally, rules governing listing, trading and settlement, penalties and prohibition, disciplinary provisions and defaults are contained in the bylaws of the stock exchange. As in case of IPA, there is a model set of bylaws. So you have to adopt those model set of bylaws. Similarly, here, so these are already contained in the bylaws of the stock exchange. Particulars as to composition of the board, powers of governing board, and membership provisions, they are contained in the articles of the stock exchange. Then recognition. In section 3, you have to apply for recognition, and in 4, the SEBI will grant you recognition. But it is discretionary power of SEBI. They may or may not grant you registration. So SEBI may grant recognition to the stock exchange if it is satisfied that the rules or bylaws of the applicant stock exchange are in conformity with the prescribed conditions, and stock exchange is willing to comply with any condition that SEBI may impose for carrying out the object of this act. The recognition would be in the interest of trade and also in public interest. SEBI may also put certain conditions while granting recognition, and such conditions may be regarding qualification, that as to who can be a member of the stock exchange, regarding the manner in which contract shall be entered into and enforced between the members, then representation of the central government. They may ask that, okay, you include representatives from central government on the stock exchange, maintenance of accounts of the members and their audit by chartered accountants, publication in Gazette. The grant of recognition shall be published in the Gazette of India and also in the official Gazette of the state in which the stock exchange is located. And the recognition, it becomes effective from the date of its publication in the Gazette of India. As the power is discretionary, so SEBI may also refuse to grant recognition to the applicant, but then naturally an opportunity of being heard will be given, and the reasons should be communicated in writing. So stock exchange will communicate in writing as to why it is refusing this registration. Restrictions on alteration of rules. The rules of a recognized stock exchange related to members specified in point 5 above shall be amended only with the approval of SEBI. Suppose you have already lodged with SEBI that, okay, we'll be following these rules or bylaws, then any amendment thereto has to have approval of SEBI, and you cannot amend those rules without the approval of SEBI. Then this is a very important concept, this concept of corporatization and demutualization. What is this corporatization? So it means the succession of a recognized stock exchange being a body of individuals of a society registered under the Societies Act by another stock exchange being a company. So earlier it was a society or body of individuals which was registered under Societies Registration Act. Now it is being converted into a company, incorporated for the purpose of assisting, regulating, or controlling the business of buying, selling, or dealing in securities carried on by such individuals or societies. So this is the concept of corporatization. So corporatization means succession of a recognized stock exchange. Earlier it was a body of individuals or society, because earlier recognition was being awarded to body of individuals or societies also. Now this concept of corporatization. And what is this demutualization? So it means the segregation of ownership and management, because ownership in stock exchanges is kept separate from the management, because they are privy to certain type of information which the members could use to their advantage. So there is a segregation of ownership and management from the trading rights of members of a recognized stock exchange in accordance with a scheme approved by SEBI. So demutualization, in ordinary parlance, you can understand that, okay, there is no concept of mutuality here. So members are different and management is different. Then different organizational forms. Different stock exchanges, they operate in different organizational forms and structure: association of persons, body of individuals, societies, companies limited by shares, company limited by guarantee. So why this need was felt? Why this corporatization and demutualization concept came? It came to promote investor protection and to regulate transactions in stock exchanges and to avoid undesirable speculation and scam. The central government decided to make every stock exchange as a corporated entity limited by shares. Earlier, AOPs, BOIs, they were also being recognized as stock exchanges, but for a better control and to promote investor protection and to regulate transactions and to avoid undesirable speculation and scam, the central government decided that, okay, let all stock exchanges be converted into corporate entities limited by shares. And another thing was to separate ownership, trading, and management in a stock exchange, demutualization. Because in societies, there is a concept of mutuality, that members are doing service, members are the one who are contributing, members are the one who are availing the services. But here, there is a concept of demutualization, and ownership and trading are kept separate. Appointed date. Appointed date concept is very important, and appointed date we read in various other laws also, like MSME Act is there, Micro, Small and Medium Enterprise Development Act. There also there is a concept of appointed date. Here also there is a concept of appointed date. So all recognized stock exchanges shall be corporatized and demutualized as per the provisions contained in section 4B on and from the appointed date. Acha, can anybody tell me where this appointed date concept is used apart from this MSME Development Act and SCRA? Any other act?
Sir, I think it is in merger or demerger.
Yes, right. Compromise, arrangements and amalgamation. Yes. Appointed date. Yes. So whenever any scheme is approved, so there is a concept of appointed date. Appointed date means the date which SEBI may, by notification in the official gazette, appoint. Different appointed dates may be appointed for different stock. So they can put a question also on this, that the concept of appointed date is not given in which of the following acts. So they may give you 3 or 4 options like Companies Act, MSME Development Act, SCRA, and they may include one, say, Partnership Act. So that way also they can put questions. So different appointed dates may be appointed for different stock exchanges. And if SEBI is satisfied that any recognized stock exchange was prevented by sufficient cause from being corporatized and demutualized on or after the appointed date, it may specify another appointed date for that stock exchange, and such stock exchange may continue as such before such appointed date. Simple. अभी तक किसी को कोई दिक्कत नहीं हुआ मेरे ख्याल. We are discussing very simple concepts.
Sir, appointed date again, please repeat, sir.
हाँ, appointed date में क्या है? देखिए ऐसा है. Earlier, stock exchanges were being recognized in the form of, say, body of individuals or association of persons, societies also. But then it was felt that, okay, just to check scams and all those things, to regulate them better for investor protection, let them all be converted into companies. And this is the date when they will be converted into companies. So there were 2 concepts, corporatization and demutualization. Corporatization means conversion of existing body of individuals or AOPs or societies through which these stock exchanges were being run, to convert them all into companies. So this is the concept of corporatization. And naturally, the SEBI will notify in the official gazette that, okay, by this date, all of you have to, this is something like last date. But suppose some stock exchange, they were not able to, that they may extend the date also, and they may notify a fresh date before which all these stock exchanges may be corporatized. I hope I'm clear on this.
Yes, sir. Thank you, sir. Thank you.
Now, this procedure for corporatization, मेरा भी नींद खुला रहेगा, आप बीच में सवाल पूछते रहा करो. Procedure for corporatization and demutualization. So what is the procedure for this? First of all, they have to submit a scheme. because we are presuming that some of the stock exchanges were being run prior to this as AOP or BOI or societies. So now, since they have to be converted into a company, so they have to submit a scheme. So all recognized stock exchanges referred to in section A shall, within such time as may be specified by SEBI, submit a scheme for corporatization. They will definitely submit a scheme. How this AOP or BOI or societies will be converted into company. And a recognized stock exchange whose name has already been corporatized and demutualized by SEBI by notification in the official gazette need not submit any scheme fresh. Okay. So some of them were already corporatized or demutualized, then they did not submit the scheme. Otherwise, those who are not yet corporatized and demutualized, they will submit a scheme for approval of SEBI. Scheme. What is the scheme? It means a scheme for corporatization or demutualization of a recognized stock exchange, which may provide for issue of shares. Naturally, because earlier it was an AOP or BOI or society, there were no concept of shares. But now there is a concept of shares in company. So how shares will be issued? Issue of shares for a lawful consideration or provision for trading rights in lieu of membership card of the members of a recognized stock exchange. Then restrictions on voting rights, transfer of property, business, assets, rights, liabilities, recognitions, contracts of the recognized stock exchange, legal proceedings by or against the recognized stock exchange, whether in the name of the recognized stock exchange or any trustee or otherwise, and any permission given to or by the recognized stock exchange. So this scheme will discuss in detail how all these aspects are to be dealt with when this existing BOI or AOP or society is to be converted into a company. Then transfer of employees of recognized stock exchange to another stock exchange. Any other matter required for the purpose of or in connection with the corporatization or demutualization, as the case may be, of the recognized stock exchange. So by the time this meeting is over, you will have a very good idea of SEBI regulations. आपको अभी लग रहा होगा SEBI regulations are very difficult, but ऐसा कुछ नहीं है. These are very simple. Approval. On receipt of the scheme, SEBI may approve the scheme with or without modification after making such inquiry and obtaining further information. And we will try to have a case study also. Not today, but some other day on this SEBI regulations. Because sometimes case studies come on this SEBI regulations. On receipt of the scheme, SEBI may approve the scheme with or without modification after making such inquiry and obtaining further information, if any, as it may require, and if it is satisfied that it would be in the interest of trade and also in public interest. Then ineligible conditions. So what are the circumstances in which SEBI will not approve the scheme? First, if the issue of shares for a lawful consideration or provision of trading rights or payment of dividends to members have been proposed out of any reserves or assets of the stock exchange. So if these conditions are not satisfied or not met properly, then they will not approve the scheme of corporatization. Then publication in Gazette. So when the scheme is approved, it shall be immediately published by SEBI in the official Gazette and the recognized stock exchange into, just a minute. Now this publication in Gazette. So when the scheme is approved, it shall be immediately published in the official Gazette and the recognized stock exchange in two daily newspapers circulating in India as specified by SEBI. And once the scheme is published, the scheme shall have effect and be binding on all the persons and authorities, including all members, creditors, depositors, and employees of the recognized stock exchange, and on all persons having any contract, right, power, obligation, or liability with or against, over, to, or in connection with the stock exchange or any members. And in case scheme is rejected, so it may by order reject the scheme. Such a rejection also shall be published, because till now the stock exchanges was functioning. It was functioning as an AOP or BOI, but now because the scheme has been rejected, so now it is no longer operative. So this rejection of the scheme of stock exchange of conversion of AOP or BOI into a corporate form If it is rejected, then such rejection also shall be published in the official gazette. And the persons concerned and concerned recognized stock exchange shall be given a reasonable opportunity of being heard naturally. And restrictions or conditions for approval. So while approving the scheme, SEBI may by an order restrict voting rights of shareholders, because earlier they may be having more voting rights. So restrictions could be there while approving the scheme on voting rights of shareholders who are also stock brokers of the recognized stock exchange, rights of shareholders or a stockbroker to appoint the representatives on the governing body, because they are trying to segregate the management from trading rights. So that is the basic intent. And maximum number of representatives of stockbrokers of the recognized stock exchange to be appointed on the governing board of the recognized stock exchange, which shall not exceed 1/4 of the total strength of the governing board. So if they want to appoint representatives of stock brokers, then it will not exceed 1/4 of the total strength of the governing board, so that governing board is separate from this stock broker. So this is the concept of demutualization. The all restrictions shall be published in the official gazette, and on publication thereof, the order shall have full effect, notwithstanding any contrary provisions of the Companies Act or any other law. Another provision is regarding 51% shareholding by public. So every recognized stock exchange, ये म्यूट कर दीजिए, कहाँ से भी आवाज आ रही है. तो every, I understand कि भाई संडे है, थोड़ा बहुत होता ही है, बट फिर भी आप म्यूट कर लेंगे तो बढ़िया रहेगा, सभी के लिए बढ़िया रहेगा. 51% shareholding by public. Every recognized stock exchange in respect of which the scheme for corporatization or demutualization has been approved shall, either by fresh issue of equity shares to the public or in any other manner as may be specified by SEBI regulations, ensure that at least 51% of its equity capital is held by the public other than shareholders having trading rights. So 51% shareholding has to be by public. And such compliance shall be made within 12 months from the date of publication of the order. And SEBI can extend the above period by another 12 months on sufficient cause being shown to it, and if it is satisfied as being in the public interest. Manner of increasing public shareholding. You can, because this PPT is being shared with you, so you can always write your own notes. Even in this PPT also, if you want to write notes, so you can click to add notes. So as here at the bottom, you can add your own notes, because some of the provisions are self-explanatory. So you can make notes ke bagi this provision is important, or you can highlight those provisions. Manner of increasing public shareholding. So normally I share in PPT form only and not PDF, because PPT normally you can easily edit. So manner of increasing public shareholding. The guidelines in this respect are provided in Securities Contracts Regulation, manner of increasing and maintaining public shareholding in recognized stock exchanges regulations. So these are the regulations as to how this public shareholding will be increased to 51%. So recognized stock exchanges shall ensure that at least 51% of its equity share capital is held by the public, either by fresh issue of equity shares to the public or through issue of prospectus, or in the following manner. So either it can be by fresh issue or it could be in the following manner. Suppose some shareholders already have got the shares, so they will offer for sale their shares. So offer for sale by issue of prospectus of shares held by the shareholders having trading rights therein. Placement of shares held by the shareholders having trading rights to such persons or institutions as may be shortlisted by the recognized stock exchange with the approval of the board. So board here means SEBI. Issue of equity shares on private placement basis by recognized stock exchange to any person or group of persons not being shareholders having trading rights or their associates, subject to the approval of the board. So it could be by a way of offer of sale. The existing shareholders who are having trading rights, they may offer their shares for sale. Or placement of shares held by the shareholders having voting rights to such persons or institutions. SEBI may shortlist certain persons or institutions that, okay, you offload your shares to such persons. Or it could be on private placement basis by the recognized stock exchange to any person or group of persons not being shareholder having trading rights. Basically, they want to separate the trading rights from shareholding rights or voting rights. This is the concept basically. any combination of the above. And now shareholding and transferability restrictions on equity share capital. So this is the restriction. So persons resident in India individually or together, directly or indirectly, maximum is they can hold up to 5% of the paid up capital. Stock exchange, depository, clearing corporation, banking company, maximum 15%. Persons resident outside India, because you have to read these provisions with IPA regulations. So IPA regulations, they also contain similar provisions that are okay, how shareholding will be controlled. So these are something similar. So persons resident outside India, combined holding of all persons, maximum is 49%. That means persons resident outside India have to be in minority only, maximum up to 49% they can hold, and 50%, 51% is to be held by persons resident in India. FDI is 26%, and foreign institutional investors it is 23%. And foreign investor single, maximum he can hold up to 5%. So this is the shareholding and transferability restrictions. Now withdrawal of recognition. Suppose the stock exchange was recognized, name was published in the official gazette. Now SEBI wants to withdraw. How it will be withdrawn? So SEBI may serve a written notice on the governing body of a stock exchange stating that SEBI is considering withdrawal of recognition, considering the interest of the trade or in the public interest. So by way of a public notice, they may withdraw the recognition. And failure to the recognition granted to stock exchange shall stand withdrawn if the stock exchange has not been corporatized or demutualized within the specified time, or the stock exchange fails to submit the scheme within the specified time, or the scheme has been rejected by SEBI. So in either of these, it was not corporatized, it was not demutualized, or it failed to submit the scheme, or the scheme has been rejected. So in all these circumstances, SEBI may serve a notice on the governing body of stock exchange that okay, SEBI is considering withdrawal, and you please put forth your submission on this. And an opportunity of being heard shall be given to the recognized body of stock exchange. Validity of prior contracts, because some of the contracts may have been entered into earlier prior to withdrawal. So this withdrawal of recognition, it will not affect the validity of the contracts entered into or made before the date of notification. To provide for this, after consultation with the concerned stock exchange, SEBI shall make such provisions as it deems fit in the order withdrawing recognition or order rejecting the scheme under section 4B5. And with this withdrawal of recognition, it will also be published in the official gazette. So every action taken by SEBI, be it recognition, be it withdrawal, be it approval of scheme, be it rejection of scheme, all these things are published in official gazette. Clearing corporation. What is this concept? With the prior approval of SEBI, a recognized stock exchange may transfer the duties and functions of a clearing house to a clearing corporation, being a company incorporated under the Companies Act, for the purpose of periodical settlement of contracts and differences thereunder, delivery of and payment for securities, any other matter incidental to or connected with such transfer. So these clearing corporations, they are also sought to be corporatized. Bylaws, because it is easier to control. Bylaws, for transfer of the duties and functions of a clearing house to a clearing corporation, every such clearing corporation shall make bylaws and submit them to SEBI for its approval. Because as we know, stock exchanges were there earlier also. They were being run as AOP or BOI or societies. Now they are being converted into companies. So these clearing houses, they are also being converted into clearing corporations. Approval by SEBI. On being satisfied that it is in the interest of the trade and also in the public interest to transfer the duties and functions of a clearing house to a clearing corporation, SEBI may grant the approval. Next, powers of the government or SEBI. What are the powers? To grant recognition to stock exchange, because the power basically lies with the central government, which has delegated the power to SEBI. Similarly, in case of IBC, powers are with central government, who have made this IBVI as the regulator. So similarly here, SEBI is the regulator. So these are the various sections. And these are the powers. So to grant recognition, to withdraw recognition, to call for information and explanation, to call for annual report returns, to approve rules of stock exchange, to direct rules to be made or to make rules of stock exchange, to supersede the governing body of a recognized stock exchange, to suspend business of a recognized stock exchange, to declare contracts in notified areas illegal, to prohibit contracts in certain cases of undesirable speculation, to exempt any class of contracts from the application of Securities Contracts Regulation Act or any provision thereof. So these are basically the powers of SEBI or central government. Now, powers of central government SEBI to call for information from stock exchange. This is given in section 6 and 7. Periodical returns. So every recognized stock exchange shall furnish to SEBI the prescribed periodical returns. Relating to its affairs. Then maintenance of books of accounts. Every recognized stock exchange and every member thereof shall maintain the books of accounts and other documents as prescribed by the central government in consultation with the concerned stock exchange. So we have to see the rules in this regard. And these books of accounts and other documents will be preserved for a period not exceeding 5 years as prescribed by the central government. SEBI may conduct inspection also, subject to inspection by SEBI at all reasonable times. Then regarding this records, calling for information and inquiry into the affairs of stock exchanges or members. So this is given in section 6. In the interest of the trade or public interest, SEBI may call upon the stock exchange or any member to furnish in writing such information or explanation relating to the affairs of the stock exchange or of the members in relation to the stock exchange as SEBI may require. So it may call upon the stock exchange or any of its members to furnish them in writing such information or explanation relating to the affairs of the stock exchange or of the members in relation to the stock exchange as SEBI may require. It may appoint one or more persons to make an inquiry into the affairs of the governing body of a stock exchange or the affairs of any of the members of the stock exchange. Something similar, because these inspection provisions, they are available in IBC also. IBBI may order inspection or investigation of any IP or IPE or IPA also. So similarly, here the stock exchange, the SEBI may appoint one or more persons to make an inquiry in relation to the affairs of the governing body of a stock exchange or the affairs of any of the members of the stock exchange in relation to the stock exchange and submit a report to the result of such inquiry to SEBI within the specified time, or in the case of an inquiry in relation to the affairs of any of the members, direct to the governing body to make inquiry and submit its report to SEBI. So for governing body, they may appoint one or more persons, and in case inquiry or inspection is to be done regarding a member, then they may ask the stock exchange to make the inquiry and then submit the report to SEBI. As in case of this IPA also at times orders inquiry into the affairs of the IP. Then duties vis-a-vis inquiry. So where an inquiry in relation to the affairs of a recognized stock exchange or the affairs of any of its members has been undertaken, then every director, manager, secretary, or other officer of stock exchange, every member of stock exchange, and if the member is a firm, every partner, manager, secretary, or other officer of the firm, or every other person or body of persons who has or had dealings in the course of business with any of the persons mentioned above, whether directly or indirectly, shall be bound to produce before the authority making the inquiry all such books of accounts and other documents in his custody or power relating to or having a bearing on the subject matter of such inquiry, and also to furnish the authorities with any such statement or information relating to as may be required of him within the specified time. Suppose an inquiry is taking place regarding stock exchange or a member, so then every person who is associated with it or who has dealings with such member or stock exchange is bound to produce books of accounts or other documents in his custody having a bearing on the subject matter. Then furnishing of annual report. This is given in section 7. Every recognized stock exchange shall furnish to the central government with a copy of the annual report containing the prescribed particulars. Then to instruct the stock exchange to punish the erring member. This is given in section 9. The contravention of any of the bylaws shall render the member concerned liable to one or more of the following punishments. So he may be put some fine, if some fine may be imposed on him, or even he may be expelled from membership. He may be suspended for membership for a specified period, or any other penalty of a like nature not involving the payment of money. Like he may be prohibited from trading, etc. Now, powers of central government or SEBI to direct rules to be made. What is this? Section 8. Section 8 says that SEBI can direct the recognized stock exchanges to make any rules or to amend any rules already made in respect of all or any of the matters specified. And SEBI, in this case, before making an order, what SEBI will do? SEBI will consult the governing body of the stock exchange generally, or the concerned stock exchange in particular. So they may call for a meeting of all the stock exchanges, or it may consult individually the stock exchange. Then it will form an opinion that is necessary or expedient to make such order, and it will specify the reasons for making such order. So it may ask a recognized stock exchange to make rules on any of the matters which they specify. Compliance of the order. So recognized stock exchange shall make or amend the rules within 2 months from the date of SEBI order. And if it fails or neglects to comply within 2 months, then SEBI may make or amend rules of the stock exchange. So earlier they will ask them to amend the rules themselves, and if they don't, then SEBI will amend the rules of the stock exchange. Publication of rules. The rules made or amended, they will also be published in Gazette of India and also in official Gazette of the state, in which the principal office of the recognized stock exchange is situated, and the rules made or amended shall have effect then. Any question on till this point? Now, powers of central government or SEBI to suspend the business of a recognized stock exchange. Section 12. What could be the reason? SEBI might feel that, okay, there is some emergency, and for the purpose of meeting the emergency, it is expedient to suspend the business of the stock exchange. SEBI shall issue a notification in the official gazette that the business of the recognized stock exchange has been suspended, specifying the reasons. So first of all, there could be an emergency. Second is, by way of notification, the business of recognized stock exchange may be suspended, and the suspension of such business shall be subject to such conditions and for such period not exceeding 7 days as may be specified in the notification. Just a minute. So, SEBI may extend the period of suspension by issuing a fresh notification, but at a time suspension can be for 7 days, and it can be extended also by issuing a fresh notification in the official gazette. And the extension may be ordered if such extension is in the interest of trade or public interest. For extension of suspension period, an opportunity of being heard should be given to the governing body of the stock exchange. अभी तक देखिए all are self explanatory. कहीं कोई मुश्किल वाली बात नहीं है. You have to simply understand. कहीं पर भी wherever timelines are given, तो timelines आपको remember कर लेनी है. And there is a space click to add notes, है ना? तो यहाँ पर आप इसको अपने notes भी PPT में डाल सकते हैं. Next क्या बोलता है?
Yes, sir, here what is the expected type of questions in the exam, sir?
By questions could be, they may ask that, okay, this corporatization concept is very important. So they may ask a question that corporatization means. So they may give you some options. Demutualization, what it means. What are the powers? Can anyone who is concerned with the stock exchange, suppose a person is dealing in stock, so who are the persons who may be required to produce books of accounts or other documents to SEBI? So they could put questions on any of these.
Oh, sir.
So you can
Thank you, sir.
you can frame your own questions, or we will. I think some MCQs are available in books also, so you can go through those books.
Okay,
But
thank you, sir.
first of all, you have to have a basic understanding, and once you develop a basic understanding, you can frame your own questions. And you can write those questions in click to add notes. There is a space here, na? Click to add notes. So you can write here your own questions. So powers of the central government under SCRA. So central government can exercise the following powers in addition to the powers which are given earlier. What are the powers? To notify areas for the licensing of dealers, to delegate powers to SEBI, RBI, to make rules under SCRA, to grant immunity from prosecution of offences. So these are some of the other powers of central government. Then powers of central government to make rules. First of all, rule making powers. थोड़ा typing में कई बार हो जाता है, making हो गया ये making है. The rule making power. The central government may, by notification in the official gazette, make rules for the purpose of carrying out the objects of this act, and the rules may provide for manner in which applications may be made. They can put a question like this, that okay, power of central government to make rules include which of the following, or does not include which of the following. They may specify 3-4 things. So central government may, by notification in the official gazette, make rules for the purpose of carrying out the objects of the trust. Manner in which applications may be made, particulars which they should contain, and the levy of a fees in respect of such application. Manner in which any inquiry may be made for the purpose of recognizing. And so for this purpose, the central government will make rules by notification in the official gazette. So applications, particulars, levy of fees, manner of inquiry, conditions which may be imposed for grant of recognition, including conditions for as to admission of members if the stock exchange concerned is to be the only recognized stock exchange in the area, and the form in which such recognition shall be granted. So central government may make rules. Then particulars which should be contained in the periodical returns and annual reports to be furnished to the central government. Documents which should be maintained and preserved under Section 6, and the periods for which they should be preserved. Normally it is 5 years. Manner in which any inquiry by the governing body of a stock exchange shall be made. Manner in which the bylaws to be made or amended under this act shall, before being so made or amended, be published for criticism, for objections. Manner in which applications may be made by dealers in securities for licenses under Section 17, fees payable in respect thereof and the period of such licenses, conditions subject to which licenses may be granted, including conditions relating to the forms which may be used in making contract documents, etc. To be maintained by licensed dealers, and the furnishing of periodical information to such authority as may be specified, and the revocation of licenses for breach of conditions. And these requirements shall be complied with by public companies for the purpose of getting their securities listed, by collective investment schemes for the purpose of getting their units listed. And what could be the grounds on which the securities of a company may be delisted from any stock exchange? This is given in Section 21A, subsection 1. Form for appeal which can be filed by which can be filed before Securities Appellate Tribunal is given in 21A2, 22A, 23L, and the fees payable in respect of such an appeal. Manner of inquiry is given in 23(1), and any other matter which may or which is or may be prescribed. So central government can make rules regarding these. So central government may, by notification in the official gazette, make rules for the purpose of carrying out the objects of this act. And the rules may provide for parliamentary consent. So they may say that, okay, for these particular purposes, consent of the parliament will also be required. So every rule made under Section 30 shall be laid as soon as it is made before each house of parliament while it is in session for a total period of 30 days, which may be comprised in one session or in 2 or more successive sessions. And if before expiry of the session, immediately following the session of the successive session aforesaid, both houses agree in making any modification, or both houses agree that the rule should not be made, the rule shall thereafter have effect only in such modified form or be of no effect as the case may be. And any such modification or amendment shall be without prejudice to the validity of anything previously done under that rule. So central government is having the power to make rules. And it says that every rule which is made under Section 30, it will be laid before each house of parliament. And it will have effect accordingly. And anything done previously will have no effect as to its validity.
So I have a question here.
Yes, yes.
So this process of approval from Parliament,
Mhm.
is it general in nature for all the laws so that we need not be very specific about this, or this is specific to this act?
No, no, no. They are actually they are saying कि what rules could be made regarding these points. So section 30 you have to read, no? So section 30 says that okay, in which manner application will be made, what will be the particulars, what will be the fees, in what manner inquiry may be made. So all these section 30 says that what are the circumstances for which rules have to be made. So rules have to be made regarding these things. ये सारे पॉइंट्स दिए हुए ना इसमें.
Okay, right, that I understand.
हाँ.
I was referring to the approval process in Parliament, like both the houses, 30 days and all that stuff. Is it general in nature for all the fiscal laws, or is it specific to this act?
No, 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 no. It is not law like IBBI. IBBI now has been granted the power to make regulations. So
Okay.
regulations they can make on their own.
But rules have to be rooted through
Yes, yes. Rules have to be routed to Parliament in case of IBC also. Oh, yes. Now this powers exercisable by SEBI. So SEBI, what are the powers? In general, powers have been delegated to SEBI by central government, but there are certain specific powers which are given in specific sections. Like section 8A talks of power to grant approval to clearing corporation, power to approve bylaws, to make or amend bylaws, to issue directions, to recognize stock exchange, then licensing of dealers, power to compel listing of securities, to appoint adjudicating officer, to make regulations. Powers of SEBI to make or amend bylaws of stock exchanges. So this is given in section 10. So they can also amend the power to make or amend the bylaws of the recognized stock exchange. So section 10 empowers the SEBI to direct any stock exchange to amend its bylaws. These provisions are as follows. Power. So SEBI may make bylaws for all or any of the matters specified under section 7 or amend bylaws made by a stock exchange under section 9. Now, how this power to make or amend bylaws can be exercised? So this power to make or amend bylaws can be exercised on its own motion, on suo motu, or if the stock exchange makes a written request to SEBI in this regard. So it could be by the stock exchange also that, okay, you please make or amend this bylaw, or it can be done by SEBI on its own. SEBI will consult the governing body of the stock exchange before making or amending the bylaws, and the reasons for making or amending the bylaws should be recorded in writing. Then bylaws so made or amended shall be published in the official gazette of India and also the official gazette of the state in which the principal office of the stock exchange is situated. And the bylaws shall have effect only from the date of its publication in the Gazette of India. And what is the effect of SEBI's order? On the publication of bylaws in the Gazette of India, the bylaws so made or amended by SEBI shall have effect as if they had been made or amended by the recognized stock exchange concerned. भाई देखिए ऐसा है कि at least you should have 1 or 2 readings. I think 19 marks are there for these allied laws. 4 plus 7 plus 8. 4 marks for
एक तो स्टडी है सर, यू नेवर नो किस में से आएगी,
हाँ।
कौन से लाइट लॉ की आ जाएगी।
हाँ, तो उसमें
8
सेबी में
नंबर
भी
की तो सीधी सीधी स्टडी है जी,
सेबी में भी आ जाती है कई बार,
किसी में भी आ सकती, कंपनीज
हाँ।
एक्ट, सेबी,
हाँ,
सेल्स ऑफ
बिल्कुल,
गुड्स
बिल्कुल।
एक्ट, कॉन्ट्रैक्ट
हाँ।
एक्ट, कहीं से भी आ जाती है।
हाँ।
तो 8 नंबर तो सीधे सीधे वो है।
तो अब आप ये देखिए कि 19 जो मार्क्स हैं, 19 मार्क्स के लिए so objections to amendment where SEBI makes or amends the bylaws of a stock exchange on its own motion, because it may make or amend suo motu also. So the governing body of the stock exchange, it will apply to SEBI for revision thereof within 2 months of publication in the Gazette. So they may ask question like, what is the period? In case SEBI has suo motu made or amended the bylaws of the stock exchange, within what period SEBI, this stock exchange may apply to SEBI. So it has to be done within 2 months of the publication in the official gazette. After giving an opportunity of being heard, SEBI may revise the bylaws so made or amended. The revision shall have effect only from the date of its publication in the Gazette of India. And previous publication condition, the making or amendment or revision of bylaws under section 10 shall be subject to the condition of previous publication. However, if SEBI is satisfied that in the interest of trade or in the public interest, any bylaws should be made, amended or revised immediately, it may by order in writing specifying the reason thereof dispense with the condition of previous publication. So normally previous publication, first of all, they have to be published and then they will become applicable. But if there is some emergency and if SEBI is satisfied that in the interest of trade or in public interest, these bylaws should be made, amended or revised immediately. So it may either dispense with the condition of previous publication. It may say, okay, you make them effective now, let publication follow. Now, powers of SEBI to issue directions to a recognized stock exchange. So SEBI may issue directions in the interest of investors or orderly development of a securities market, or to prevent the affairs of any recognized stock exchange or clearing corporation or such other agency or person providing trading or clearing or settlement facility in respect of securities being conducted in a manner detrimental to the interests of investors or securities market, or to secure the proper management of any stock exchange or clearing corporation or agency or persons referred to in clause B. So it may issue directions. ठीक है, रूल्स आ गए, डायरेक्शंस आ गई, बाइलाज आ गए. ठीक है. Inquiry. SEBI may issue directions after making or causing to made an inquiry for section 12A purposes. Directions. SEBI can issue appropriate directions in the interest of investors to any stock exchange or clearing corporation or agency or person referred to in point 1B above, or any person or class of persons associated with the securities market. To any company whose securities are listed or proposed to be listed in a recognized stock exchange, as may be appropriate in the interest of investors in securities and the securities market. So what is the scope of section 12A? What is the scope of power? So section 12A powers which are given in section 12A, they include the power to direct any person who made profit or averted loss by indulging in any transaction or activity in contravention of the provisions of the SCRA or regulations to disgorge an amount equivalent to the wrongful gain made or loss averted by such contravention. Okay. Similar provision regarding disgorge are available in IBC. Can anybody tell me where are those provisions contained? IBC में भी कुछ है, ठीक है ना? वो जो पेनल्टी वाले आपके प्रोविजंस हैं उसमें ये क्लॉज दिया हुआ, तो ये डिस्गॉर्ज वाली कॉन्सेप्ट आईबीसी में कहां पर है? कैन एनीबॉडी टेल मी? भाई सपोज a person suffers a loss because of the action of IP or liquidator, so then he can make an application in a prescribed form. I think form A is the form, and he has to claim the loss, that okay, by his action I have suffered a loss, and that in that case that amount may be disgorged from the person who made some wrongful gain. तो कोई बता सकता है कौन से सेक्शन में दिया हुआ है वो? आईबीसी में भी सिमिलर प्रोविजन है. आपको मेरे हिसाब से ये शायद पेनल्टी वगैरह में मिल जाएगा.
रेगुलेशंस में होगा सर, सेक्शंस में तो
हाँ वही हाँ हाँ हाँ
235 में रेगुलेशन करता है, सेक्शन 235 में.
हम्म.
लेकिन उसके जो रेगुलेशंस हैं आगे वहां पे ये बात करता है डिस्गॉर्ज करने की.
हाँ जी, कोई बता सकता है कहां पर है ये?
ये सर जो रेगुलेशंस हैं 14 नंबर रेगुलेशन है ये, इंसॉल्वेंसी एंड बोर्ड के इंस्पेक्शन एंड इन्वेस्टिगेशन को।
ओके,
where the direction has been issued to any person to disgorge the amount under subsection 4 of section 220, the board shall endure to realize the amount of disgorgement expeditiously. The board shall, यही आप कह रहे हैं
बिल्कुल बिल्कुल,
फॉर्म ए विद इन 30 days
हाँ
of
फॉर्म है, हाँ वही। हम्म। तो मेरा पर्पज ये था कि भाई वहां पर भी सिमिलर प्रोविजंस हैं एंड वी शुड मेक ए कंपैरिजन, उससे थोड़ा सा आप मिला करके पढ़ेंगे तो जल्दी समझ में आ जाएगा। आप ये मत सोचिए कि बोरिंग है या सभी रेगुलेशन समझ में नहीं आ सकते, बहुत सारे लोग तो छोड़ जाते हैं इनको, वो कहते हैं हमने पढ़ना ही नहीं है। लेकिन मान लो सपोज दे आस्क यू के स्टडी, फिर क्या कर लोगे आप? फिर तो 8 मार्क्स डायरेक्टली गॉन।
आईबीसी के सेक्शन 220 में डिसिप्लिनरी कमेटी है,
हाँ
उसमें इसके बारे में बात है।
हाँ
220 में उसने तो खाली सेक्शन डिफाइन कर दिया, उसको कैसे करना है वो आगे है। 220 में जो दिया है ना, वो तो पेनल्टीज के बारे में बात करता है कि क्या क्या पेनल्टीज हो सकती है।
220 का जो 3 है, वेयर एनी इन ये 220 का 4 आ गया। Notwithstanding anything contained in subsection 4, the board may direct any person who has made unlawful gain or averted loss by indulging in any activity in contravention of this code or the rules to disgorge an amount equivalent to such unlawful gain or aversion of loss.
उसको आगे डिफाइन कर दिया ना जिन्होंने, जो
हाँ
वो रेगुलेशंस में कर दिया।
उन्होंने कह दिया भाई रेगुलेशंस में कर देंगे। हाँ,
हाँ जी।
तो सेक्शन 220 सबसेक्शन 4 में दे टॉक ऑफ दिस कॉन्सेप्ट, और ये इसका फिर रेगुलेशन भी है, इंस्पेक्शन एंड इन्वेस्टिगेशन रूल जो आप बता रहे थे, रूल ये है आपका है रेगुलेशन 14 रेस्टिट्यूशन।
जी
आगे चलते हैं सर। पावर्स ऑफ सेबी टू मेक रेगुलेशंस अंडर, और आप ये मत सोचो कि मुझे पता है, मैं भी यहीं से पढ़ रहा हूं, जैसे आप पढ़ रहे हो तो मैं भी यहीं से पढ़ रहा हूं, वो ऐसा ही है, मुझे भी उतना ही आता है जितना आपको आता है। पर ये है कि मुझे एग्जाम नहीं देना, आपको एग्जाम देना है, तो आपको थोड़ा सा याद रखना पड़ेगा, बस और कोई बात नहीं। और 2-4 बारी आप पढ़ोगे ना, देखो ऐसा होता है कुछ ना कुछ तो याद रह ही जाएगा। आप इसको 3-4 बारी पढ़ लो, क्या दिक्कत है? अभी तो रिकॉर्डिंग भी हो रही है, तो रिकॉर्डिंग को भी आप सुन सकते हो। तो पावर्स ऑफ सेबी टू मेक रेगुलेशंस अंडर एससीआरए सेक्शन 31 क्या है? तो सेबी में मेक रेगुलेशंस कंसिस्टेंट विद द प्रिंसिपल्स ऑफ द कोड of the act or rules to carry out the purpose of this act by notification in the official gazette। अब यहाँ ये आगे regulations, ठीक है। regulations में क्या होगा? फर्स्ट ऑफ ऑल एज वी नो 51% जो पब्लिक की शेयर होल्डिंग होनी है, तो हाउ दिस विल बी हेल्ड? मैनर इन विच एटलीस्ट 51% ऑफ द इक्विटी शेयर कैपिटल इज हेल्ड विद इन 12 months फ्रॉम द डेट ऑफ पब्लिकेशन ऑफ द ऑर्डर, ठीक है, बाय द पब्लिक अदर देन द शेयर होल्डर्स हैविंग ट्रेडिंग राइट्स। तो जिनके पास ट्रेडिंग राइट्स है other than those should hold majority of the shareholding, ठीक है। and eligibility criteria and other requirements in section 17A for securities issued under debt securitization process, then parliamentary consent, ये जो भी रूल्स वगैरह उसके लिए पार्लियामेंट की कंसेंट जरूरी। then regulating securities transactions, regulating transactions in securities, this is given in section 13 to section 19। क्या बोलता है? Only recognized stock exchanges can transact except with the permission of the central government. No person shall organize or assist in organizing or be a member of any stock exchange other than a recognized stock exchange for the purpose of assisting in or entering into or performing any contract in securities, ठीक है। तो इसमें किसका क्या मतलब हो गया कि यू कैन डील थ्रू ओनली थ्रू रिकॉग्नाइज्ड स्टॉक एक्सचेंज एक्सेप्ट विद द परमिशन ऑफ द सेंट्रल गवर्नमेंट। अपना कोई प्राइवेट स्टॉक एक्सचेंज नहीं आप बना सकते, ठीक है। तो ट्रांजैक्शंस नॉट एंटर्ड थ्रू मेंबर्स ऑफ द रिकॉग्नाइज्ड स्टॉक एक्सचेंज आर इलीगल। देखो स्टॉक एक्सचेंज में बहुत सारी ट्रांजैक्शंस होती हैं जो आउटसाइड द एक्सचेंज भी होती हैं, ठीक है, लेकिन वो सब इलीगल ट्रांजैक्शंस। आपने पेपर में पढ़ा होगा कि सच एंड सच पर्सन वाज अरेस्टेड फॉर डब्बा ट्रेडिंग, ठीक है ना, तो वो सब इलीगल ट्रांजैक्शंस है। एवरी कॉन्ट्रैक्ट एंड सिक्योरिटीज इन द notified states or areas shall be illegal. Transactions in contravention of bylaws will be void. अगर जो भी bylaws हैं, इसकी भी importance है. And if any transaction is done in contravention of bylaws, it will be void. So any contract entered into in any state or area specified in the notification, which is in contravention of any of the bylaws, shall be void. और इसकी जो exceptions हैं, वो दी हुई है Rule 14 में. Members not to act as principals. So generally, because they are dealing on behalf of investors, ठीक है ना? तो जो members of stock exchange है, they are acting in a fiduciary capacity. So generally, the members of the stock exchange will carry out the transactions and dealings on behalf of investors. Hence, the investor is the principal and the member or stockbroker is his agent. Therefore, the members cannot enter into contract as principals except in specific circumstances. इस पर सवाल पूछ सकता है. They can frame a question on this. है ना? 1 mark question पूछ सकता है. In a dealing between a member of a stock exchange and an investor, who is the principal? Investor is the principal. And who is the agent? Member or stockbroker is the agent. Therefore, the members cannot enter into contracts as principals except in specific circumstances. Then, undesirable speculation contracts prohibited. If the central government or RBI or SEBI is of the opinion that it is necessary to prevent undesirable speculation in securities in any states or area, it may declare by way of a notification in the official gazette that no person in such states or area shall enter any contract for the sale or purchase of any securities except with the permission of the central government, RBI or SEBI. All contracts entered into after the date of the notification shall be illegal. Then derivative contracts. So contracts in derivative shall be legal and valid only if such contracts are, first of all, they are traded on a recognized stock exchange, they are settled on the clearing house of the recognized stock exchange, or between such parties on such terms as the central government may notify. Transactions not entered through members of recognized stock exchange. So section 13 talks of illegal transactions. So every contract and securities in the notified states or area shall be illegal unless it is entered into between members of a recognized stock exchange or through or with the members of recognized stock exchange. So SEBI can notify any states or area for the purpose of section 13, having due regard to the nature and volume of transactions in securities in such state or area. And where this section 13 will not be applicable, so section 13 will not apply to spot delivery contracts as are defined under section 2, subsection 1, unless such exemption is withdrawn by SEBI. Transactions between two members of stock exchange. So any contract entered into between two members of stock exchange shall be subject to such terms and conditions as stipulated by the respective stock exchange with prior approval of SEBI. So it's not that two members of stock exchange cannot enter into contracts between amongst themselves. They can also, but it has to be with the prior approval of SEBI. And it may be subject to such terms and conditions. And second is it will require prior permission from the respective stock exchange if so stipulated by the stock exchange with the prior approval of SEBI. Then transactions that contravene bylaws, void. Section 14 talks of transactions which are void. कितना है और देखते हैं अभी 62. बस ज्यादा नहीं है, इसको यहीं पर खत्म करेंगे, उसके बाद में थोड़ा सा ब्रेक लेंगे, ठीक है ना? इसके बाद थोड़ा सा ब्रेक ले लेंगे और फिर एक रेगुलेशन और कर लेंगे. हाँ, तो ट्रांजैक्शंस दैट कॉन्ट्रावीन बायलॉज. ट्रांजैक्शंस दैट कॉन्ट्रावीन बायलॉज क्या बोलता है? void. So void contracts, any contract entered into in any state or area specified in the notification which is in contravention of any of the bylaws shall be void. As respects the rights of any member of the recognized stock exchange who has entered into such contract, as respects the rights of any other person who has knowingly participated in the transaction entailing such contravention. ठीक है? So regarding the rights of any other person, it has to be done knowingly. ठीक है? और एज रिस्पेक्ट द राइट्स ऑफ एनी मेंबर ऑफ द रिकॉग्नाइज्ड स्टॉक एक्सचेंज, उसके लिए क्या होगा, ये वर्ड होगा ही होगा, ठीक है, which is in contravention of any of the bylaws specified. Then contracts with utmost good faith protected. So the above shall not be construed to affect the rights of any person other than a member of the recognized stock exchange. Okay? To enforce any such contract or to recover any sum under or in respect of such contract if such person had no knowledge that the transaction was in contravention of any of the these IE laws. ये IE क्या होता है? Specified under section 93A. 93A में देखना पड़ेगा क्या है. Other exclusions. So section 14 shall not apply to spot delivery contracts as defined under section 2(1) unless such exemption is withdrawn.
हाँ जी, हाँ जी.
Then restrictions on members of recognized stock exchange to act as principal. ठीक है, ये हमने पहले भी पढ़ लिया कि they have to act as agent. ठीक है, और principal कौन है? जो person entering into the contract है. ठीक है. So this is principle of agency. So generally members of stock exchange, they carry out transactions and dealings on behalf of investors. So investor is the principal, they are the agent.
तो मॉडर्न में ही आएगा, वो तो हो नहीं सकता ना, वो तो चेंज नहीं कर सकते ना.
थोड़ा सा म्यूट कर दीजिए जो है पाटिल जी, म्यूट कर दो. कहाँ पवन जी का आ रहा है आवाज लगता है. हाँ जी. So principle of agency. So generally members of a stock exchange, they carry out transactions and dealings on behalf of investors. So investor is the principal और जो member broker है वो agent है. ठीक है, ये तो याद रखनी है, पूछ सकता है इस पर. एक नंबर का सवाल तो पूछ ही सकता है. Therefore the members cannot enter into contract as principals except in specific circumstances. क्या exception है? Exception ये है कि where the contract is a no member of a recognized stock exchange shall enter into any contract as principal with any person other than a member of the recognized stock exchange except in the following cases. पहला, where the contract is a spot delivery contract. ठीक है, और क्या है? दूसरा है where the member of the recognized stock exchange secures the consent of such other person in writing within 3 days from the date of the contract or discloses in the note, memorandum or agreement of sale or purchase that is acting as principal. ठीक है, तो या तो उसको पहले से डिस्क्लोज करना पड़ेगा, जो उसका ब्रोकर नोट होगा उसमें देना पड़ेगा कि इज एक्टिंग एज प्रिंसिपल, अदरवाइज नहीं कर सकता ट्रांजैक्शन. देन प्रोहिबिशन ऑफ अनडिजायरेबल स्पेकुलेटिव कॉन्ट्रैक्ट्स. तो नो पर्सन इन द टेरिटरी टू व्हिच दिस SCRA एक्सटेंड्स shall, except with SEBI's permission, enter into any contract for the sale or purchase of securities other than a contract falling under any one or more of the following, namely spot delivery contract, contract for sale or purchase of securities or contracts and derivatives, contracts for preemption, including right of first refusal or tag along or drag along rights contained in shareholders agreements or articles of association of companies. Then contracts in shareholders agreements or articles for purchase or sale of securities pursuant to exercise of an option contained therein to buy or sell securities. क्या क्या conditions हैं? जो title है, the ownership of the underlying securities held continuously by the selling party to such contract for a minimum period of 1 year from the date of entering into. तो minimum holding period कितना होना चाहिए इसमें? 1 year. At the price or consideration payable for the sale or purchase of the underlying securities is in compliance with all the laws, and the contract is settled by way of actual delivery of the underlying securities, and the contract shall also be in accordance with the provisions of FEMA. Licensing of dealers. So इसमें क्या है कि recognized stock exchange की जो members है उसके अलावा आपको licenses भी issue कर सकते हैं. तो section 17 talks of issue of licenses. So section 17 requires a person dealing in securities to obtain a license from SEBI. So unless such license is obtained, no person shall, whether on his own behalf or on behalf of any other person, carry on the business of dealing in securities in any state or area which has not been notified and has been notified by the central government for section 17 purposes. Notification 17 में क्या है? It will be issued with respect to any state or area if the central government is satisfied having regard to the manner in which securities are being dealt in such state or area that it is desirable or expedient in the interest of trade or public that such dealing should be regulated by a system of licensing. Exclusion क्या है? anything done by or on behalf of a member of any recognized stock exchange, तो वो that will not be subject to licensing. और जो spot delivery contracts है वो भी इसमें नहीं होगा unless such exemption is withdrawn. Then securities issued under DEVT securitization process. ये क्या है? ये हमारा जो ये प्रोसेस है, सेक्शन 17A applies to securities issued under debt securitization process. इसमें duties of issuer है, the issuing company, special purpose distinct entity, it will fulfill the eligibility criteria and other requirements as per SEBI regulations. It will apply for listing in one or more recognized stock exchanges before issuing the offer document to the public, and it will repay all the monies collected under the offer document within 8 days if the listing permission is refused or not granted. ठीक है, उसके बाद में ये क्या है? नोट, इफ मनीज आर नॉट रिपेड विद इन 8 days आफ्टर द इश्यूर इज लायबल टू रीपे इट, उसमें क्या आपको इंटरेस्ट देना है 15% पर एनम का, और जो डायरेक्टर है या ट्रस्टी है उनकी जॉइंट एंड सेवरल लायबिलिटी आ जाएगी. इन रेकनिंग द 8th डे इंटरवीनिंग पब्लिक हॉलीडेज, तो यहाँ पर ये पूछ सकता है, ये सवाल पूछ सकता है कि हाउ दिस पीरियड ऑफ 8 days विल बी रेकन्ड, या रेट ऑफ इंटरेस्ट क्या देगा, 15% देना है आपको. So in reckoning the 8th day, the intervening public holidays under Negotiable Instrument Act shall be disregarded. If the 8th day itself is a public holiday, the next day shall be considered. तो basically working days है, public holidays को उन्होंने exclude कर दिया. और public holidays कौन से? जो Negotiable Instruments Act में दिए गए. And all other provisions of SCRA relating to listing of securities of a public company on a recognized stock exchange shall apply to securities issued under debt securitization process. उसके बाद में कहता है राइट्स ऑफ ट्रांसफर और ट्रांसफरी टू रिसीव डिविडेंड्स. ठीक है, हमने क्या पढ़ा था कि भाई while applying for scheme, if the scheme proposes that okay, to the existing association of persons or body of individuals this dividend will be transferred, then SEBI will not approve the scheme. So section 27, 27A and 27B talks of rights of the transferor or transferee to receive dividends. Transferor's right क्या है? The holder of any security issued by any company or any securities being units or other instruments issued by a collective investment scheme or any securities being units or other instruments issued by a mutual fund. ठीक है, जिनका भी नाम अपीयर हो रहा है बुक्स ऑफ कंपनी में या कलेक्टिव इन्वेस्टमेंट स्कीम में या म्यूचुअल फंड में, दे विल बी एंटाइटल्ड फॉर डिविडेंड. ठीक है, एंड द होल्डर शैल हैव सच राइट नॉटविथस्टैंडिंग दैट द सेड सिक्योरिटी हैज ऑलरेडी बीन ट्रांसफर्ड बाय हिम फॉर कंसिडरेशन. ठीक है, ट्रांसफरी का क्या राइट है? एक्स डिविडेंड और कम डिविडेंड वाली कॉन्सेप्ट आपने पढ़ी होगी ना. However, the transferee who claims the dividend or income from the transferor has lodged the security and other documents required for making the transfer of security within 15 days of the date on which the dividend income became due. ठीक है, तो ट्रांसफरर को डिविडेंड मिलेगा या ट्रांसफरी को डिविडेंड मिलेगा, ये इन सब कंडीशंस पर डिपेंड करेगा. ठीक है, सपोज द transferee, he has lost the security within 15 days of the date on which the dividend income became due. The transferor will have no right to retain such dividend and he will have to part with such dividend to the transferee. अच्छा, ये जो 15 days का पीरियड है ये कैसे एक्सटेंड होगा? सपोज देयर इज अ डेथ ऑफ ट्रांसफरी, तो एक्चुअल पीरियड टेकन बाय हिज लीगल रिप्रेजेंटेटिव टू एस्टैब्लिश हिज राइट, वह तब तक वो एक्सटेंड करेगा. Loss of transfer deed by theft or any other cause beyond the control of the transferee, actual period taken for replacement thereof. और delay in lodging of security to actual period of delay, तो उसमें ये जो है ये 15 days period could be delayed also. Exclusion क्या है? Nothing contained in the aforesaid provision shall affect the right of a company to pay any dividend or income to the holder of the security or the right of the transferee to enforce against the transferor or any other person his rights, if any, in relation to the transfer in any case where the company has refused to register the transfer of the security in the name of the transferee. Applicability of SCRA to certain delivery contracts. कुछ specific delivery contracts हैं. ठीक है, उसमें क्या क्या मतलब है? ये commodity derivatives का क्या मतलब है? Specific delivery contract is defined in section 2HA और ये कहता है कि commodity derivative which provide for the actual delivery of specifying qualities or types of goods during a specified future period at a price fixed, specified or to be fixed in the manner thereby agreed to, and in which the names of both the buyer and the seller are mentioned. तो ये होता है specific delivery contract. क्या क्या चीजें दी हुई है, क्वालिटी भी दिया हुआ है, टाइप ऑफ गुड्स भी दिया हुआ है, पीरियड भी डिफाइंड है, प्राइस भी डिफाइंड है, बायर सेलर भी डिफाइंड है. जब ये सब चीजें डिफाइंड है तो वो स्पेसिफिक डिलीवरी कॉन्ट्रैक्ट है. ठीक है. अच्छा, नॉन ट्रांसफरेबल स्पेसिफिक डिलीवरी कॉन्ट्रैक्ट क्या है? तो इट इज a specific delivery contract, the rights or liabilities under which or under any delivery order, RR, bill of lading, warehouse receipt or another document of title relating thereto are not transferable. ठीक है, तो अगर ये ट्रांसफरेबल नहीं है तो ये नॉन ट्रांसफरेबल स्पेसिफिक डिलीवरी कॉन्ट्रैक्ट हो गया. उसके बाद ये ट्रांसफरेबल स्पेसिफिक डिलीवरी कॉन्ट्रैक्ट क्या है? इट इज a specific delivery contract which is not a नॉन ट्रांसफरेबल. ठीक है, तो नॉन ट्रांसफरेबल इन्होंने डिफाइन कर दिया. नॉन ट्रांसफरेबल में बोल दिया कि भाई देखो, आपको पहले बता दिया स्पेसिफिक डिलीवरी कॉन्ट्रैक्ट क्या है. ठीक है, स्पेसिफिक डिलीवरी कॉन्ट्रैक्ट है जिसमें सब चीजें डिफाइंड है. ठीक है, क्वालिटी भी, टाइप भी, पीरियड भी, प्राइस भी, बायर सेलर भी, ये तो हो गया स्पेसिफिक. ठीक है. नॉन ट्रांसफरेबल कौन सा है? नॉन ट्रांसफरेबल वो है कि जिसमें क्या डिलीवरी आपको रेलवे रिसीट से, बिल ऑफ लेडिंग, वेयर हाउसिंग रिसीट से मिलेगी और वो नॉन ट्रांसफरेबल है. तो ये नॉन ट्रांसफरेबल स्पेसिफिक डिलीवरी कॉन्ट्रैक्ट हो गया. ठीक है, जिसके नाम आरआर बनी हुई है, जिसके नाम बिल ऑफ लेडिंग है, उसी को मिलेगा. फिर ट्रांसफरेबल क्या है? इट इज अ स्पेसिफिक डिलीवरी कॉन्ट्रैक्ट which is not a non-transferable specific delivery contract and which is subject to such conditions relating to transferability as notified by the central government. Restrictions क्या है? No person shall organize or assist in organizing or be a member of any association in an area to which the provisions of section 13 have been made applicable, which provides facilities for the performance or any non-transferable specific delivery contract by any party thereto without having to make or receive actual delivery to or from the other party, the contract to or from any other party named in the contract. ठीक है. अच्छा, ये एप्लीकेबिलिटी ऑफ दिस सिक्योरिटीज कॉन्ट्रैक्ट रेगुलेशन एक्ट सेक्शन 30A क्या बोलता है? ये नॉन ट्रांसफरेबल स्पेसिफिक डिलीवरी कॉन्ट्रैक्ट्स. तो जनरल रूल क्या है? जनरल रूल ये है कि ये जो SCRA है, सिक्योरिटीज कॉन्ट्रैक्ट रेगुलेशन एक्ट, इट विल नॉट अप्लाई टू नॉन ट्रांसफरेबल स्पेसिफिक डिलीवरी कॉन्ट्रैक्ट्स. ठीक है. एक्सेप्शन क्या है? सो सेंट्रल गवर्नमेंट कैन नोटिफाई दैट SCRA will apply to non-transferable specific delivery contracts if that government is of the opinion that in the interest of trade or in public interest, such application can be for notified classes of non-transferable specific delivery contracts or specified areas or specified goods or class of goods or specified manner. अच्छा, अब ये जो ट्रांसफरेबल स्पेसिफिक डिलीवरी कॉन्ट्रैक्ट क्या है? इसमें ये है कि where in respect of any area the provisions of section 13 have been made applicable in relation to commodity derivatives for the sale or purchase of any goods or class of goods, so central government may notify that in the said area or any part thereof, all or any of the provisions of Securities Contract Regulation Act will not apply to transferable specific delivery contract for the sale or purchase of the said goods or class of goods either generally or to any class of such contracts in particulars. अच्छा, अब ये लास्ट पेज रह गया आपका. पावर्स ऑफ स्टॉक एक्सचेंजेस क्या दी हुई है? They can make rules restricting voting rights subject to central government या SEBI approval. They can make bylaws subject to SEBI approval. They can establish additional trading floor subject to SEBI approval. They can specify the eligibility criteria to be fulfilled by issuer of securities. और उसके अलावा 21 और 20A also talks of certain powers of the stock exchanges under SCRA. ठीक है जी. तो यहां तक हमारा SCRA था. अब हमें SATC करना है. तो SATC अब बाद में करते हैं, है ना. 11:44 हो गए. या तो ऐसा करते हैं, थोड़ी देर का ब्रेक ले लेते हैं, 10 मिनट का. ठीक है, 10 मिनट का ब्रेक लेकर के मुझे भी थोड़ा रेस्ट मिल जाएगा और